What I want to talk about this evening is the question of secrecy in justice and the scrutiny of security and intelligence agencies in democratic society and how those two concepts might be related. So I'm going to be talking about the British security and intelligence agencies, MI5, which is our domestic security service, MI6, which is our overseas security service, and GCHQ, which is the government agency which is responsible for surveilling electronic communication. So for those of you who are American, the equivalent of the GCHQ would be the NSA, and the equivalent body for MI5, MI6 would probably be the Central Intelligence Agency. The importance of some of the concepts that I'm going to be discussing tonight, I think, is underlined by the Edward Snowden affair. Has everybody heard of Edward Snowden? Everyone knows who Edward Snowden is. Everybody knows that Edward Snowden is presently in Russia, that he's been subject to what was initially a sealed charge, but is now an unsealed charge in the United States, that he's been involved in passing over intelligence information. And everybody, I suppose, knows that a British newspaper, The Guardian, has been primarily responsible for publishing the material which he has disclosed. Now, in the United Kingdom at least, the legality of some of the programs that he has exposed, some of the GCHQ, NSA programs, has been called into question. In other words, some people have been arguing that what GCHQ has been doing, what one of our intelligence agencies has been doing, is unlawful. And in the United States, some NSA operations have been subject to very trenchant criticism in Congress, including by Senator Dianne Feinstein, a California senator who chairs the Senate Oversight Committee, the relevant Oversight Committee. Now, in the United Kingdom context, secrecy in justice and the oversight of our security and intelligence agencies, these two concepts were linked in a recent piece of legislation which became law a few months ago. And this piece of legislation is a piece of legislation I'm going to discuss with you tonight. And it's called the Justice and Security Act. The Justice and Security Act had two parts, and it did two different things. Firstly, it altered parliamentary oversight of our security and intelligence agencies. Secondly, it introduced into civil litigation procedures, that means non-criminal litigation in the United Kingdom, something called the closed material procedure. So the first time, effectively, in our civil litigation, it's possible for the judge to exclude one of the parties and hear evidence in the absence of that party. This would normally happen where the government was being sued, the UK government was being sued by someone in court, and the government wanted to inform the court of some material supporting the government's case, which couldn't be revealed in public for fear of breaching national security. So, for example, someone wants to sue the British government because he's been held in Guantanamo Bay, and he feels that the British government should have done something to get him out. The government might want to deploy some intelligence material to show that this man is in fact a dangerous terrorist. But it doesn't want to reveal that information in public because to do so would reveal the source of the information. In the past, the government would simply have to not contest the case. Now, if the judge agrees, the government can tell the judge in secret, in private, the information it wants to pass over, and the man from Guantanamo Bay who's suing the government will never know what that information is, and may never know why the case against him has been decided against him.